Okay, another category is legal briefs. We don't always brief at the temporary hearing phase. A lot of the issues before the court are common. The court has heard them every day. You don't need to brief the court on how to calculate child support. They do that every day. But you might have a unique issue where you do need to brief. And a common one that you might want to brief to really shine a light on it is on a modification. So this is post-divorce. They're going back for a motion to modify. If it is within a year or within a short time of the divorce, they have to show, the person pleading has to show there has been a material change of circumstance. And the circumstance has to relate to the modification they're asking for. So there's some great case law out there on that, and it might be beneficial in that instance to brief the court. Maybe you have a strange gift issue. So let's say it's a divorce and the client is saying, look, I need to stay in the house because the house is my separate property, and the other side is saying, no, it's not, and it's gift. Maybe it's a gift argument, and that's why your client's saying it's separate property. Maybe you need to brief that for the court to show them, look, you can't, she's not going to end up in the house long term because it's my house, so you might as well put me in it now. So there might be areas where you want to brief. So you just want to think about that and determine if you do, and if you are briefing for the court, you want to have copies of the cases. It might be all you have is copies of the cases. You don't necessarily have to write a brief, but you might want to write a brief. If you write a brief, you definitely also want to have copies of the cases and highlight them. Again, don't make yourself or everyone dig through that whole case. Highlight and tab the important parts so that if you need to stand up and read something from that case, you would be able to do that. Sometimes you won't know what angle exactly the other side is taking. And so you will have read a lot of the case law and you'll have it with you. And you'll want to have, okay, are they going at it this way? Are they going at it that way? And highlight those cases. And I've had instances where I did that, and I was so glad that I did, because the other side stood up and made an argument. And I had a case right on point that said, nope, they're wrong. Here's the case. That's so fun when you can do that. But you have to spend a little bit of time in the cases and anticipating, you know, what are the arguments. Either you can kind of see some of them from their pleading, or once you start researching the topic, whatever the topic is, you may start seeing, oh, this is where the case, these are the topics the case law looks at and that the courts are looking at when they're deciding that issue. And then you'll start to see, okay, in this case they said that part, that you can't do that. In this case they said, oh, that part is important. And then just highlight. It'll be, you know, piecemeal, case by case. But if you had 3 or 4 cases on different topics, you know, different pieces of that topic, you can highlight them and have them with you. You wouldn't, again, need to have 15 copies of it all because you may never use it. But if you had 1 copy at least, you could hand that copy to the court, and that might win the day for you. So that could be very fun.